Okay, good afternoon. My name is Ronaldo Hilton. I'm the chairperson designated of the New York State Loft Board. Welcome to a January 19, 2017 public meeting. And again, I just want to wish everyone a very happy New Year, 2017. Hopefully, see great things at the Loft Board. Before we begin, I just want to introduce our newest member of the board, Mr. Robinson Hernandez, who's the manufacturer representative of the Loft Board. And give him an opportunity to say hello.
Hi, good afternoon. My name is Robinson Hernandez. I'm currently the executive director for what's called the Urban Tech Hub at Grand Central Tech. I have 11 years of working with government, also responsible for the designation of industrial business zones. Worked very closely with manufacturing organizations throughout the city. We've gotten to know them well, and I'm looking forward to being part of the board. Thank you.
Welcome, Robinson. I just want to quickly apologize to the public for the delay in letting you in. We just had to just kind of went over into our private session a little bit. But we first turn to a vote on the minutes of November 17, 2016 public meeting. Are there any corrections or comments to the meeting, to the minutes? None. So is there a motion to accept the minutes? Thank you, Ms. Shelton. Is there a second? Is there a second to the thank you, Mr. Shelton? And Ms. Rivera?
Mr. Hubbard.
I was at the day, so I'll have to abstain. Thank you.
Mr. Bush.
Yes.
Mr. Fernandez.
Stay.
Mr. Green.
Yes.
Mr. Chaka.
Yes.
Ms. Shelton.
Yes.
Chairperson Hilton.
Yes. Thank you, Mr. Rivera. We'll now hear from the Executive Director, Helen Balsam. She'll now give a report.
Good afternoon, everybody. The first thing I wanted to report today is that staff has begun redrafting the rules for the Loft Board. And we have a working draft of Chapter 1, although not quite ready to present to you yet. We hope to present the rules for the board's consideration in April or May. We will certainly, since it is a huge project, we'll give you at least a month, two, if you need to actually review the draft of the rules. Next, in December, I just wanted to report that we had received some complaints of no heat, hot water, or gas from several of the tenants at 57 J Street. We did send our inspector out. He did write and serve violations. The landlord actually cured the conditions very quickly. We have had some intermittent complaints of intermittent service since then, and we're trying to work through what's causing those, and hopefully everything will be fine in the building all the time. In addition to that enforcement action, we worked with DOB to facilitate an inspection at 255 18th Street in Brooklyn, where we had received complaints from tenants alleging a number of very dangerous and illegal conditions, including no working sprinkler system. DOB did issue several violations, but fortunately the tenants did not have to vacate.
Excuse me?
Yes.
No, I didn't hear what you said.
DOB did issue several violations, but fortunately the tenants did not have to vacate, which is always what we're concerned about, is that the tenants would wind up on the street. On December 29, 2016, the Appellate Division First Department issued a decision in the case of Grant versus the New York City Loft Board. The board had found that the tenant, Stephen Grant, failed to timely object to the owner's plan to legalize the fourth floor units of the building as 2 units. Grant wanted them legalized as 4 units. Grant argued, he sued. The Supreme Court actually dismissed the case, and Grant appealed, and the Appellate Division found that the board's determination was rationally based in the record and not contrary to the law, and that Grant had actually waived his right to object to the configuration because although he attended the narrative statement conference and raised a number of issues, he didn't actually raise that issue. So I thought that was worthy of reporting. Just to update you on the registrations, we are down to 30 owners who have not renewed their registration for last year, which is a little up from the year before, so I'm not happy about that. We're double checking all of the owners' addresses and we'll be sending them notices, hopefully by the end of this month, for failure to register. And that's it.
Question, just a notice, or is this going to be some sort of fine?
It will be a fine if they don't work.
Thank you, Ms. Paulson.
Yes, excuse me, I have a couple of questions.
Sure.
First, as I stated in our private meeting, I'd like to place on the record that today the board elected to meet in private to discuss cases on the agenda for today's public meeting. It's the first time the board's done this in my over 30 years on the board. And while it can be justified on Section 108 of the Open Meetings Law, potentially, of the Public Officers Law, there's no provision in the board's current rules under Section 103 or 105 to provide holding such a meeting in which no minutes or recording was made. So, in my view, if there is the potential to meet in private, it could only be done after 103 and 105 are amended, and I would encourage the board, based on what got discussed today, to consider the wisdom of doing it.
Does anyone want to comment further on that?
I would just say that legally the board is allowed under the Public Officers Law Section 108 to meet in its quasi-judicial capacity. It does not have to be a public meeting. It is exempt under the Public Officers Law. That's
And I do have a couple of questions. With regard to the heat complaints in the minutes from the November meeting, you said you were going to look into a mechanism to kind of report on those. Is it just going to be you're summarizing them in each meeting?
if that's acceptable to the board. If you want more, if you want statistics, I mean, we did start a database and we are tracking complaints. So if you want more, we can give you more.
I would say it depends on if you're getting 2 or 3 complaints a month. I don't think it rises to the level. If you're getting 30 or 40, then I think where they are, you know, kind of some more data points would be useful.
So the Loft board has begun the process of documenting and tracking, so it will take a while to start building some statistics to report to you. But I suppose as some interesting cases come up, or some significant cases, I should say, we will report that.
And I think particularly persistent cases, if you have complaints month after month in a single building, that might warrant being brought to people's attention. I'm sure it's just coincidence that 255 18th Street has 2 cases on the agenda today. They have those issues, but
Oh, it is a coincidence.
yeah, indeed. You mentioned that you're working on redrafting the rules, and if I understand correctly, this redrafting of the rules is designed to make them more comprehensible rather than to create policy changes.
I mean, we are looking at streamlining processes, and we've received some suggestions, which we are considering. So, there may be some process changes. To that extent, they are still the board's rules, and the board will say yea or nay accordingly.
I was asking about policy or processes.
Well, I think that the process is, the changes in the process result from policy considerations. So, if there's something specific, maybe I'm just not understanding what you mean exactly by policy consideration.
Well, I could give you dozens of examples, but rather than just editing them for being easier to read and follow the plain language guidelines, if there were to be changes that would address some of the issues that we discussed in private. I think it would be very nice if, at a minimum, the board members were given a chance to provide input and have a discussion of what areas might be under review, rather than having 400 pages of rules redrafted, kind of dropped out of.
I mean, as we discussed on the one-on-ones, it's hard for me to say what is important to each of you. So I'm kind of looking for you to tell me what's important. You just expressed a concern about 103 and 105. I took notes on that. We're going to look at that very closely. So I'm not sure, you know, it's
Well, I
the
suppose,
horse leading the cart leading the horse.
will we have an opportunity to look at the draft prior to voting up or down on the entire package?
Absolutely.
Okay, all right, so.
As a matter of fact, the rules require that.
Okay.
So, and we're not changing it.
And I suppose what Elaine is also saying is that if there are any concerns you may want to move forward, or maybe you.
Well, I'll give you an example. I'll give you a perfect example. Every owner of an IMT that's registered with the New York City Loft Board is required to file a monthly report.
Right.
Very few do. They're all out of compliance. So, do we want to enforce that law? Do we want to ignore that law? Do we want to consider moving it to a quarterly filing?
We wouldn't water down the law because they're not doing it. I think it's enforcement, right?
Pardon?
I think it would be an enforcement matter.
I think
This
We're not looking to take.
Ronaldo, you know something? I don't want to booby trap you. I think it's safe to say that the vast majority of owners are out of compliance with this.
I think that that's not true, and the only reason that I can say that is because we, last month, were looking into starting to enforce that provision,
Okay.
and we actually put together a list of owners that are not in compliance, and there are, what was it, 30 or 50 that have not filed
A
anything.
little more than 50 that have not filed for 2016, but every other building in our jurisdiction has filed one. So we are on top of it. It is something that we look at when we issue letters of no objection
Has filed one.
for 2016.
They're supposed to file monthly, correct?
Yes. We're going to start, when we start enforcement, if we start enforcement, we're going to start with the ones that have not filed anything,
Let
and
me-
then work our way.
Let me rephrase my concern. I think a significant number, I think the number of owners who have filed a monthly report every month for the 4 or 5 years that this has been on the Loft books is a very small fraction. There may be owners who check in every 6 months, but technically they're all coming way short of what the rules are.
Are you sure of that? I mean, I don't know where you. Can I take what my staff says?
Can I just so Chuck, you were raising this, I think if I understood correctly, you were raising this on a sort of, not because this was, you know, the burning issue for you per se, but because this was a symbolic example of the type of thing that
It's symbolic of the type of topic that, in my opinion, if the board is looking at rewriting the rules, rather than have the board write out vast changes to all the rules, if the board came up with 15 topics that we're thinking about taking a look at, and we'd like to get some input from the board members before we publish the first draft. Because in my experience, once drafts get published, that's a significant step down the road toward them becoming rules. So,
We can't publish without your approval.
No, I think it's suggested before you start drafting things, to poll the board, see what does the state are the issues. Maybe chapter by chapter now, you know, like, last time a schedule was put out, right?
when we did all the 2010 amendments?
Yeah, it was a schedule, like, we're gonna be looking at this month, and we try to keep to it. Sometimes I gotta slow down, but I think just give us a heads up, so this is what we're looking at. Do you have anything you want us to address specifically? Give more the opportunity to sort of input it before you start drafting. Because you might spend a lot of time on it because you don't think it's important, because the whole state's is important. So I think that's what you're suggesting. It's a little bit of input from this side before they start rethinking it.
I just wanted to comment that I think we're going through a middle part here of a leadership transition change. And I think the leadership is doing an outstanding job. They've already reached out to us, and offered us the opportunity to basically take the rules and say, this is what we have, this is my opinion as the fire department representative of what maybe we should tweak. And I sort of agree with our executive director that I think the onus is kind of on us to provide them with the information that we think that they should use. Now, granted, there's all kinds of ways to, pardon the pun, skin the cat, but you got to start somewhere. And I sort of feel like that our executive director has done that. I have spoken with her on a couple of things. I know Mr. Shacker has. So, with that being said, I think we should kind of agree to maybe disagree on what the current process is and try to, funnel this information to her in what we can agree upon as a timely manner. They've been more than open to adjusting every process that we as a board have suggested. So I don't see any reason why if we need to make some adjustments within the next 30, 60, 90 days that we couldn't continue to do that. Am I wrong?
Well, I guess the only place that I would not disagree, but take a more expansive view is we each sat individually, but we as a board, if we put our heads, for example, I'm sure each of us around the table would have a different, would have perhaps several different opinions about should landlords have to file monthly with quarterly sufficient? Should they have to file at all?
Well, and I don't disagree with you, Chuck. I think that certainly could be one approach.
Yeah.
But I just kind of feel we need to go on record here saying that it's not like there hasn't been an approach that's actually in the works. So,
I also think,
again, there's more than one way to skin the cat. So, I'm sorry.
Right, no, sorry, so I also think that in the next private meeting, let's have an opportunity to discuss it. They're coming up in this forum right now, perhaps may not be the most optimal way of addressing it. And this is where we were going to use those private meetings to have an opportunity to discuss some of these issues and say, hey, here's some feedback that we have.
I wasn't aware of more private meetings were contemplated.
Are you talking about the
The meeting
private
that we just
session?
had for private session.
So the problem with that is that rulemaking, I don't think, is a quasi-judicial function, and I think that would have to be a discussion.
I mean, a discussion on providing feedback. And
Oh.
if we're providing feedback, I think that's
Certainly, you can certainly send me whatever concerns you have individually. If you want to all discuss it together, then that would be an issue.
I understand time is also precious for everybody, and obviously everybody would probably agree that we needed to try to get together and do this if we could. What's the possibility, you don't have to answer this now, but because I think then you may need to look into it from a legal perspective, what's the possibility about group emailing questions or thoughts and getting a group email response? So that we wouldn't physically all have to be in the same, just think about that. Like I said, I don't want to put you on the spot, and there may be a clause or something somewhere that we know.
Yeah.
It also would make it easier for them, because I know just in trying to schedule my time with them, there's just, we all have so many scheduling conflicts. And again, I'm not trying to be negative to your idea. I actually support your idea. I just think we need to kind of come to some sort of truce right now and allow them to continue to massage this thing until we all get it to where everybody's on the same page.
Okay. Just a couple more questions. The 30-day period for all those buildings we ordered to register in October is now over. How did it work out?
One registered, the others we registered.
One registered and the other,
We registered them.
you registered
Yeah.
everybody else?
Yeah.
One registered.
One actually came.
All right.
Registered.
With regard to the Article 78 grant versus the law court, traditionally, Article 78 decisions get distributed to the board.
Oh, I'm
Sorry
sorry.
to ask, but-
I will send it.
Yeah.
I'm sorry, I just didn't know.
Yeah. Last question. We've got 30 owners who haven't registered. Normally, in most years, the registration deadline is July 1. So most years, they were put on notice and we were starting to levy fines long about October. So, and I realize that there's been a change in leadership and stuff, but I guess I would ask that that process be, move along as swiftly as possible.
Thank you. Any further comments based on this?
No, I'm done.
No, not you. Oh, sorry. Okay, so we next turn to the reconsideration calendar. There's only one reconsideration case. It involves BYG Realty Corp. The address is 979 to 987 Dean Street in Brooklyn. The docket numbers are 0350. Does anyone have any comments on this case?
I have a question. Not a question about the case, a question about this new procedure we're working under. Is any summary of the case and its decision given to the public?
We can certainly present a summary if you'd like. We have summaries prepared.
I would think that would be
For the reconsideration? Or for the summary calendar, or?
well, I would say the minimum for the reconsideration of the master calendar.
Mr. Delaney, you want to make a motion to that effect right now?
Excuse me?
Do you want to make a motion?
Sure. I would like to move that if we continue the policy of having case discussion in private with the understanding that questions will not be answered about cases in public, that at a minimum to let the public have some idea what on earth we're voting on, that a summary should be provided of at least the reconsideration master plan.
Okay, that. Does anyone have a second?
Can I ask a question first?
Yes.
Is this schedule published on the website for meetings?
Are the drafts also published?
Anyone second Mr. Delaney's motion to have the summaries read prior to the vote? So that motion is not going to be accepted. It's not, right? And so does anyone have any question, any comments about the case itself? Is there a motion to accept this case? Thank you, Ms. Shelton. Is there a second? Thank you, Mr. Shelton. So, Ms. Rivera, could you please forward?
Mr. Hubbard?
Yes.
Mr. Ruth?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Shacker?
Yes.
Ms. Sheldon?
Yes.
Chairperson Henson?
Yes.
7 in favor, 2 absent.
Thank you, Ms. Rivera. There are 11 summer cases, and these cases are voted in as a group. They are the Soft 5 Holding LLC at 374 Bedford Avenue in Brooklyn. Docket number is LA0049. Then Thompson, Lowback, and Susan Ryan at 270 Water Street in Manhattan. Docket numbers are PO-0010 and TA-0208. Various tenants are 57-59 Grand Street, Brooklyn, and same address, 57-59 Grand Street. And the docket number is TR0895. You have Robert Selvin, Alina Persido, Amber Kirsch, Josephine Shealy, Leandro Basile and Jesse Pesta at 8-10 Grand Avenue in Brooklyn. Docket number is TR 1010. Then you have Catherine Clark et al. And others at 46-48 Old Fulton Street in Brooklyn, TR 1100. You have Christine Giordano at 220 25th Street in Brooklyn, TR 1154. You have James Ching Chang Haye at 496 Broadway in Brooklyn, TR 1160. You have various tenants of 255 18th Street at 255 18th Street in Brooklyn, TR 1164. Then you have Sunuk Chun and others at 810 Grand Avenue in Brooklyn, TR 1167. You have Brett Herman at 476 to 498 Jefferson Street in Brooklyn, TR 1230. And finally, Amber Abraham at 108 North 6th Street in Brooklyn, TR 1306. Does anyone have any comments about these cases? Yes.
I would ask that we vote on case number 3 separately.
Very good. So we're going to vote on number 3 separately. So excluding case number 3, which is Thomas Loback and Susan Ryan at 270 Water Street, Manhattan, PO 0010 and TA 0208. Excluding those cases, does anyone have any comments on these other cases right now before we take a vote? Is there a motion to accept the summer cases, excluding number 3, which we just mentioned?
I make a motion.
Mr. Roche and Ms. Shelton? Oh, sorry. Sure. Ms. Hudson. Ms. Rivera.
Mr. Carter?
Yes.
Mr. Booth?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Chapman?
Yes.
Ms. Shelton?
Yes.
Chairperson Hilton?
Yes.
7 in favor, 2 absent.
Let's turn to case number 3. Thomas Loback and Susan Ryan at 270 Water Street, Manhattan, PO 0010 and TA 0208. Does anyone have any questions? Comments on these cases? On this case? Is there a motion to accept this case? Ms. Shelton, is there a second? Mr. Carver? Thank you. Ms. Rivera?
Mr. Carver?
Yes.
Mr. Booth?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
No.
Mr. Chapman?
Yes.
Shelton?
Yes.
Chairperson Hilton?
Yes.
6 in favor, 1 against, 2 absent.
We now come to the master case calendar. The first case is seeking deep coverage of a unit, and that case is Redsky JZ Roebling LLC at 143-155 Roebling Street in Brooklyn, docket number LC 0168. Does anyone have any comments on this case, or any comment?
I would make one comment. This is a case, as you stated, seeking deep coverage in the unit. We're going to vote. It's either going to be yes or no. And the audience won't know whether the unit was covered or not, it was decovered or not. But that's the way you want to do it. Makes no sense to me.
But the document will become, will be available to anyone once it's voted, correct?
Once the orders
Once the orders are-
are mailed out, they're uploaded to New York Law School's Center for City Law, and anybody can access them online. And they can certainly get them from us.
I will say, in defense of Chuck, I see his point, I just don't have a definitive answer figured out in my head yet what we can do to correct that. I don't want you to feel like you're the lone ranger, but I'll be honest. I just don't have an answer for you.
It's a coverage case. People watch. 4 people vote yes, 3 people vote no. Was the building covered? Wasn't it covered? It's crazy.
It's a timing question, it's not transparent. When you find out,
I'm sorry, I couldn't hear
I
you.
said it's a timing question, not an issue of transparency. Because eventually this will be published.
So, I hear you. Is there a motion, again, to present, we are prepared to do that summary, our staff is, of the cases. Is there a motion? Or do you want to repeat your?
I make a motion, I don't know if this would suffice for Chuck's concerns, but simply, before we vote, read the order.
I'm sorry.
Before we vote, read the order.
Oh, I see.
And that way,
Did we do that before?
But the master cases were always presented.
The board is, yes.
I'd like to make a motion that we, if I'm not out of line of doing this, that we table this concept for 30 days while we all have time to back away and get this thing through. I personally do not feel like everybody has enough information on all sides of this right now to necessarily make the best decision for the citizens of the city. I think we need to table it for 30 days, shoot some ideas to our executive director, and come back prepared to vote on it next month.
I mean, the motion that some.
The motion that you have about presenting the summary
Prior to the vote.
prior to the vote, I'm making a motion that we table that for 30 days, come back to it next month with prepared to vote on it next month.
Need a motion.
He's making.
I just.
Oh, you're making a motion, oh, okay, gotcha. All right, is there a second?
Yes,
One,
Just one quick, so we will, but what's going to happen now?
Brett, what do we do now with the remaining cases that we're about to vote on?
Well, I mean,
Do you want to read have the proposed orders read aloud, or do you want to go?
I think for now you have to follow the current protocol. And because basically what we're saying is we think we should possibly make a protocol change.
If you watched a football game and the score was 28-4, but you didn't know who won,
I'm not. We're not disputing.
If the score is 28-4, you know who won.
I think it's a chance for us to digest. I suggest.
Hopefully if it's just coming
proposed
Sunday,
orders, and that way people will.
I'm not disputing you. I'm just simply
I
saying
understand.
that
One thing perhaps we could.
I don't want us to make a knee-jerk decision here on this.
One thing perhaps we could all agree upon is there's some questions about how this was going to work that we hadn't quite thought through.
Well, that's what my motion was for, to give us 30 days. In other words, it's on the record that we're going to come back prepared to vote on the summary issue next month after we've had time.
Can I make a motion? So I'll make a motion that our staff read at least the recommendation on each case and before we take a vote. Is there
Can I
any
just
second?
clarify that that's just for this block, for today,
No, going forward.
going forward?
Is that a motion?
But that's.
Yes.
Yeah, for the master calendar
The
case.
master
A
calendar.
massive, yes.
And reconsideration.
Doesn't that sort of defeat the motion that's already been voted on and approved?
Well, we can always go back we can go back and do it if you want.
I second.
All in favor? Excuse me.
I'll second.
Mr. Rivera.
Mr.
I got
Howard.
Mr.
Oh, sorry.
I made a motion, Mr.
I missed
Shepard.
that.
Second.
Yes, I got it.
The drama.
Okay, Mr. Howard.
Yes.
Mr. Ruth.
No.
Mr. Hernandez.
Abstain.
Mr. Delaney.
Yes.
Mr. Chapman.
Yes, of course.
Mrs. Shelton. No. Chairperson Henson.
Oh, yes. I made a motion.
Yeah. 4 in favor, 2 against, 2 absent, and 1 abstain.
Nice job.
Let's move on.
No, we still have.
I'm sorry.
I would have been willing to.
Oh, you have a motion that's on the table?
Right.
My motion was voted on and approved, that's that's why I said no to your motion, because.
No, your vote motion.
It was seconded, it wasn't voted
No, it
on.
wasn't.
Okay. I see.
Oh, wait a minute, you guys, I just want to tell you, we are so far south of Robert's Rules of Order. If your motion was seconded, the motion to table under Robert's Rules of Order is undebatable. So you would not, we're out of order making.
Well, that was my point. That's why I voted no, because I didn't think we were following.
Well, Nick, you're supposed to pound the table.
Well, we need to get him a gavel.
No, you're supposed to.
Well, I can't pound the table, you need to give me a gavel.
I just want to say something to the public. This is all in good faith. I mean, we're trying to get to something, we're trying to do something, the right thing here. So, the motion that Mr. Roach has, which we'll consider now, is, could you just please repeat your motions?
Yes, my motion was that we table the issue of reading and or providing any type of summary to the public in attendance prior to the vote until the next meeting, so that we've all had time to go back and look at this thing through 2 and 3 and 4 sets of eyes to make sure that.
I second.
I don't understand. Table the vote or just table the discussion? How?
No, we're tabling the discussion of this. Okay, there was no motion on the floor. Mr. Delaney had wanted them the cases to be either read or a summary provided. Okay, the chair hasn't had no issue with that. However, we were getting ready to make a vote on something that I personally didn't feel that we had looked at all angles of it. It just came up today, and we're kicking around all these different things. I felt that it was in the best interest of not only the public, but us, to have some time to go back and reflect on this, shoot some ideas to our executive director, and come back prepared to vote on the issue of whether we will or will not provide the summary at the next meeting. That was my intent. You second that motion. You understand?
I just did, yes.
Right. So now we have to call for that. We're not saying that that may not happen. We're simply saying we want to step away for now until we've had time to digest this and discuss.
So let me ask you, just if we vote and your motion is accepted, at the next board meeting, we will bring this up again, or?
Yes.
Yes.
And it has to be, it will have to be voted on.
Mr. Mayor.
Just a question, and then how we handle the rest of
These
it.
cases.
Yeah,
Well,
we are not.
Okay, now I have a solution for that too, okay?
Is that a different
And
motion?
you could make, well, you could make a motion that for today, for purposes of moving forward, that these cases are read. And I think you did that.
Richard, with all due respect, we're going further south of Robert's Rules of Order. Once the motion to table is made and seconded.
Yeah, but the motion I'm making has nothing to do with.
Well,
Well, I
we
see.
We can vote on yours, and then we can vote on the second thing.
I see.
Right, so if we want to continue, they should vote down your.
I mean, if we want to get in the habit of coming in here without prior notice and information and making critical decisions on how we're going to function as a board, then we make the decision. But my point is, I mean, first of all, we have a brand new member here today who this is probably very overwhelming for him. And we have an issue that nobody here expected was going to be discussed. And now we're trying to make a rock solid decision. I don't think we're prepared. If I'm running a corporation, I'm surely not going to make a decision that's going to impact the operation of the corporation
All right.
without the knowledge and of what the subsequent consequences may be.
May I say something? My recommendation is that we're prepared today to tell you what the case is about. So if you can allow the staff, as we did before, to at least say what type of case it is, it's a coverage case or whatever case, and what the last sentence is, which is the recommendation that the staff is making to the board, without going into, who answered and all of the other things. We're talking about 2 sentences that the staff will say just to get through the calendar for today. And then the issue about whether the summary will be given as could be discussed at the next board meeting.
That's what I was trying to say, but you did simplify.
So let's do it. And you're spending a lot of time on this.
Yeah.
How did we go forward?
We have a motion and a second. We have a motion and a second.
We have a motion. Mr.
Mr. Carver?
Wait. Time out. I don't mean to turn this into circus. Just let us know what the motion was again.
We're tabling the discussion of the summary presented to the attendants until the next meeting.
And we had a second, correct? Who was that?
Me or
Robinson. Okay, Mr. Hernandez. So, Mr. Rivera.
Mr. Carver?
Yes.
Mr. Rouge?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
No.
Mr. Shackman?
Yes.
Ms. Shelton?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 1 against, 2 absent.
Okay. So, excuse me one second. Just have to find my place, I'm sorry. So, I think we read this case already. This is the next case is on the master calendar is the deed coverage of a unit, which is Redsky J.Z. Robbling LLC at 143-125 Oregon Street in Brooklyn, docket number LC 0168. Does anyone have any comment on this case? Is there a motion then to accept this case? Ms. Shelton? Any second? Mr. Roach? Ms. Rivera, could you please poll the board members?
Mr. Carver?
Yes.
Mr. Rouge?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Shackman?
Yes.
Ms. Shelton?
Yes.
Chairperson Hudson?
Yes.
7 in favor, 2 absent.
Thank you, Mr. Rivera. The second case is seeking the coverage of a building, Redsky J.Z. Robbling LLC at 143-55 Rogan Street again in Brooklyn. Docket number is LN 0026. Again, does anyone have any comment on this case? Therefore, is there a motion to accept this case? Mr. Hernandez, and as Mr. Shackman said, second case, Mr. Rivera, could you please poll the
Mr.
board?
Carver?
Yes.
Mr. Rouge?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Shackman?
Yes.
Ms. Shelton?
Yes.
Chairperson Hudson?
Yes.
7 in favor, 2 absent.
The next case is a protected occupancy case, and that case involves Rihanna Esmail and Zina Zikabat at address 1083 to 1095 Flushing Avenue, Brooklyn, and docket number is P00031. Does anyone have any comment on this case? Mr. Delaney?
Yes, I realized I could just read each case when I comment, but I chose to subvert the whole process. I'm not going to do that, but I am going to comment that this is the first 3 cases on this docket where we end up fining an owner $4,000 for failing to turn in a timely fashion the 28612 sale of rights record, which resulted in the applicants in this case spending time and money, the Loft board and host spending time and money to move through the case, only to have the landlord produce the 28612 sale document after this case has begun, which of course automatically defeats the tenant's application, resulting in a waste of time and money. And I only wish to find for scheduled to be honored.
Thank you for that comment. And just so that everyone knows, that fine is by rule. Set by rule.
And I'll also comment that I've been, in my view, the process here, I would define as being levied as problems with the fine just appearing as the blue, being handed down without notice is my concern with with this group of cases.
mean, I could argue that the rule is notice. You know, you have to do something, you have to file a certain thing, a certain document at a certain time. But that's just my piece. Is there anyone else has a comment on this case?
I would just add one thing, which is, in our private meeting, I made the point that the discussion that we had is exactly the kind of discussion that should be held in public, so that owners can be put on notice. This is a perfect example of why cases should be discussed in public. Thank you.
That who should have put on notice?
If cases like these were discussed in public, then people who attend, who might be owners, or possibly every now and then we have an attorney in the audience who represents owners, that would help get the word out more quickly, in addition to the notice that we provide in the 28612 form and in our registration package. And that we're going to put on our website, because this is the first time we've ever done this.
Right. And the law board, I believe did we agree on this to send out some notice to owners? So we're going to do a mailing out, noticing, reminding owners of their responsibility. Thank you. Do we have somebody moving to accept this case?
I will.
Mr. Delaney, sorry. Ms. Shelton, are you seconding?
Yes.
Mr. Rivera?
Mr. Carver?
No.
Mr. Rouge?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Shacker?
Yes.
Ms. Shelton?
Yes.
Chairperson Henson?
Yes.
6 in favor, 1 against, 2 absent.
Thank you, Mr. Rivera. The next, we have 3 coverage cases. The first, is there a motion for the case involving James Gubelman at 442 Broadway in Manhattan, TR 0870. Is there a motion to table a vote on this case until the board has been afforded to review? Yes, the motion, Mr. Roche. Second, Mr. Carver. Ms. Rivera, could you please poll the board?
Mr. Carver?
Yes.
Mr. Rouge?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Abstain.
Mr. Shacker?
Yes.
Ms. Shelton?
No.
Chairperson Henson?
Yes.
4 in favor, 1 against, 2 absent, 1 abstain.
The motion to table a vote on this case to the board has been afforded, has not passed.
Mr. Chairman?
Yes.
As a point of information, under our rules, the chair has the right to table a case on his or her own decision, or the board can vote on it.
I just ask counsel. 1 second. that needs to table this and go on to the other cases. We'll just come right back to this. While our council is looking at that. So the next case involves, the second coverage case involves Talon Anthony Gurr and Mike Sealer at 151 Kent Avenue, Brooklyn, docket number TR1231. Does anyone have any comment on this case? No comments. Is there a motion to accept this case? Thank you, Ms. Shelton. Second. Mr. Hernandez is seconded. Ms. Rivera, would you please go ahead?
Mr. Carver.
No?
Mr. Bruce.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Schachter.
Yes.
Ms. Shelton.
Yes.
Chairperson Hudson.
Yes.
6 in favor, 1 no, 2 absent.
Thank you. The last coverage case involves Jonathan Hudson at 141 Spencer Street in Brooklyn, docket number TR1263. Does anyone have any comment on this case? Mr. Delaney.
Yes, I would just comment that this is the third of the cases where a tenant coverage application, the second one being the last case, was a losing coverage case because the landlord popped up another one of those sneaky 286-12 sales documents after the fact. So this is the third case where we will be finding the landlord $4,000, which goes to us, not to the tenants, of course, who spent the money for the case in the first place.
Any other comments? So do we have a motion to accept this case? Shelton. Anyone? Seconds. Mr. Rowe. Ms. Rivera, will you please close?
Mr. Carver.
No?
Mr. Bruce.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Schachter.
Yes.
Shelton.
Yes.
Chairperson Hudson.
Yes.
6 in favor, 1 against, 2 absent.
We're going to go to the final, well, maybe the second final, but the final case is a removal case, and that is Harrison Street Residences LLC at 7-9 Harrison Street in Manhattan, docket number LE0669. Is there any comment, or does anyone have any comment on this case? Therefore, is there a motion to accept this case? Mr. Carter. Any second? Mr. Delaney, thank you. Mr. Rivera, please poll the board members.
Mr. Carver.
Yes.
Mr. Bruce.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Schachter.
Yes.
Ms. Shelton.
Yes.
Chairperson Hudson.
Yes.
7 in favor, 2 absent.
Thank you. You go back to the first of the coverage cases, and we were at an impasse as to whether or not the chair may table discussion and vote on this case until the board has had another round, chance to review this case for the next board meeting. Absent any.
I just wanted to look at online, the current version of the rules to make sure, but I can't connect to the
What was when the previous executive director had come in? We don't remember.
At this point, I'm going to let.
Okay.
So that's on.
There's precedent.
I'm going to pretend to be counsel myself. I'm going to move to table this discussion until the next, the vote on this table discussion until the board has has had a chance to review this case once again, and I'm going to move as chair to do that. Don't need a vote on that. So finally, this concludes our January 19, 2017 Loft Board meeting. Our next public meeting will be held at 280 Broadway Right.
I just want to interject one thing before we close out. I'm not convinced in my mind that the public that is here today understands that the reason we've made some changes is actually out of concern for attorney-client privilege, which is actually benefiting both the tenants and the owners. We've had a lot of bantering back and forth here. I think it's important that the public understand that the attorney-client privilege clause is the reason why certain aspects that may, to some feel, that they may feel they're being excluded, okay? But in reality, it's because there was a concern with the new administration of protecting your attorney-client privilege. I just want to interject that. It's not that anybody in this board is trying to intentionally cloud anything. I think we're all in agreement with it.
Thanks, Mr. Roach. I'm going to ask the executive director to just explain.
That would be a great idea. Thank you.
So basically, the board, when it's discussing cases, is exercising its quasi-judicial functions. Quasi-judicial functions of board members are exempt under the Public Officers Law. In addition, in those discussions, the board members will often ask staff questions. We staff are counsel to the board. We are all attorneys, and those should be privileged conversations. So those are the two driving forces behind the change in procedure. Board members are, of course, free to comment, as Mr. Delaney and other board members did on the cases during the sessions. And we certainly encourage them to do that. But in terms of the discussion and the discussion with staff, those discussions going forward are going to be held in private session, which, as I said at the beginning, is legal.
So if you notice, I asked, at presenting in each case, we said, are there any comments on this case? And board members certainly can make their comments on the case as some of the members did earlier, but we just can't have a discussion which involves staff giving opinions to the board in public session. But I just want to explain that. I'm sorry, we should probably have done that earlier. This is the first of our new procedures that we're going to go forward with. So let me just read my closing statement once again.
Sorry about that, Mr.
No,
Chairman. I just thought it was important.
That is very good. Thank you. I appreciate that. That was necessary. So this concludes our January 19, 2017 Loft Board meeting, and our next public meeting will be held right here at 280 Broadway, 3rd floor, on February 16, 2017. Thank you very much, board members. Could you please sign and hand in your attendance sheet?